Hello, my name is Jan Bernstein. I am the founder and managing director of Bernstein and Associates, Native American Graves Protection and Repatriation Act consultants.
And my name is Jane Richardson, and I'm associate of Bernstein Associates, NAGPRA consultants.
Aboriginal Land and the Native American Graves Protection and Repatriation Act, NAGPRA. During this training, we will review available resources for identifying Aboriginal land, demonstrate their uses, and review case studies. This training will cover the definition of Aboriginal land, resources for identifying Aboriginal land, and how to employ these resources. We are going to focus this training on Section 5 of NAGPRA, the inventory provision. Section 3 of NAGPRA also includes Aboriginal land, but in this training, we will focus on Section 5 of NAGPRA, the inventory provision, rather than delving into the discovery provision. Section 5 of NAGPRA, the inventory provision, requires museums and federal agencies to develop inventories describing Native American human remains and associated funerary objects. Those inventories are to be developed in consultation with the Indian tribes and Native Hawaiian organizations who may have an interest. Through consultation, a museum or federal agency may be able to determine cultural affiliation based on the available evidence and the information shared during consultation. If that occurs, the museum or federal agency would then publish a notice of inventory completion and repatriate those individuals and associated funerary objects. Under current regulations, culturally unidentifiable inventories are also produced when a relationship of shared group identity cannot be established. And 43 CFR 10.11, the CUI rule, provides a process for facilitating the disposition of those individuals. It is under those circumstances when you use Aboriginal land to identify the Indian tribes who may have an interest and must be offered disposition. Aboriginal land can also be used to identify Indian tribes who may have an interest in consulting as you're developing your inventories, even before you've determined cultural affiliation. Aboriginal land, as defined in 43 CFR 10.11, the CUI rule, the culturally unidentifiable inventory rule, lists final judgments of the Indian Claims Commission, or ICC, or United States Courts of Claims decisions, treaties, acts of Congress, and executive orders as the resources for establishing Aboriginal land. Now, the preamble to that regulation goes further and identifies colonial treaties acknowledged by the United States government, compromises or settlements by ICC, final judgments by other federal courts, other information such as expert testimony, and other authoritative governmental determinations.
In the current form of the draft regulations that are out for public comment, Aboriginal land will be replaced by two new terms, acknowledged land and adjudicated land. Acknowledged Aboriginal land is land whose occupation by an Indian tribe has been recognized in any of the following sources: a treaty sent by the President to the United States Senate for ratification, an act passed by Congress, an executive order, a treaty between a foreign or colonial government and an Indian tribe signed before the establishment of the United States government or prior to the land becoming incorporated in the United States, another federal document or foreign government document providing information that reasonably shows Aboriginal land occupation, or intertribal treaties, diplomatic agreements, and bilateral accords between and among Indian tribes. Adjudicated Aboriginal land will be defined as land whose occupation by an Indian tribe has been recognized by a final judgment of the Indian Claims Commission or the United States Court of Claims. A final judgment also includes a judgment concerning a settlement as long as that settlement or judgment either explicitly recognizes certain land as the Aboriginal land of an Indian tribe or adopts findings of fact that do so. We use the available resources that we'll soon go over when identifying Aboriginal land during our assessment and use that information to identify groups or cases. Then we invite all the tribes that were identified during the assessment to participate in review of our research and to verify it. Then we'll revise the groups/cases based on tribal input. And from that, we'll identify manageable projects and prioritize and implement those projects. During our initial assessment, when identifying tribes who have Aboriginal land, we'll review the 1978 map of the Indian Claims Commission decisions, or ICC decisions. The Indian Claims Commissions were created by the Indian Claims Commission Act in 1946. It was established by Congress to resolve claims of any Indian tribe, band, or other identifiable group of American Indians against the United States. Claims not settled after 1978 were transferred to the Court of Claims. This map portrays the results of those cases before the U.S. Indian Claims Commission, in which an American Indian tribe provided its original tribal occupancy of a tract within the continental United States. On the left is a portion of the 1978 map showing the ICC decisions in the state of Michigan, and on the right is an index showing the ICC decision number and its correlating tribe. Another source for identifying Aboriginal land are the Indian Land Cessions. The Indian Land Cessions are a schedule of cessions with 67 associated maps that illustrate the land ceded to the United States or was reserved by the tribes between 1784 and 1894. We typically use the website called the Tribal Connections that was created by the U.S. Forest Service to identify which cessions are within a state and the tribes that are associated with those cessions. And so after we've identified the tribes who have Aboriginal land in specific counties within a state, we create groups/cases of identical sets of tribes who have Aboriginal land under the same counties. The map on the screen shows the state of Michigan and the groups/cases of tribes that have the same counties of interest concerning Aboriginal land. And so with these implementation groups, we would present them to the tribes for the review. The tribes would assess that information through the spreadsheets, PDFs, and maps that we provide for them. And they might also provide us with additional lists for tribes that should be associated with certain counties, or they'll provide us information for why they should be removed from those lists. There may be other considerations where they only have a specific site of interest within a county that they should be always consulted about. So it's critical to receive the tribe's input on this information before moving forward.
NAGPRA consultation documentation grants can fund implementation of the CUI rule. A single case can be funded by a NAGPRA consultation documentation grant. An applicant could also combine multiple cases into a NAGPRA consultation documentation grant. It would depend on a number of factors, including the number of tribes involved and the capacity of the tribes and museum to implement the project. Keep in mind that NAGPRA consultation documentation grants cannot be awarded to federal agencies, and museum and tribal applicants cannot write NAGPRA consultation documentation grants for federal collections. Now let's talk about prioritizing projects. Where do you start? A test case may be the best way to go about this. A project that maybe has one site, a smaller number of tribes whose Aboriginal land includes that location. All the funerary objects have been identified. The minimum number of individuals is clearly established. Once you've implemented that test case, then the next case you may want to initiate would be based perhaps on the interest of the tribes and their availability. The tribes may have a case that is of higher importance to them at a particular time than another case. Also, you want to think about which ones are ready to go and which ones may require additional work. While NAGPRA says you're supposed to develop your inventories based on available information, it could be that the tribes would like the museum or federal agency to verify the minimum number of individuals and to have an opportunity to identify additional associated funerary objects. One of our clients, a client in Michigan, at the behest of the tribes in Michigan, recommitted to facilitating the disposition of ancestors under their control. They did that over the course of 2.5 years. Project 1 was Michigan. Project 1 was divided up into 3 separate projects through consultation. Project 1.1 involved 11 implementation cases, 163 ancestors from 33 known counties in Michigan and 1 unknown county in Michigan. It involved 46 Indian tribes and 2 non-federally recognized Indian tribes. The 2 non-recognized tribes were included at the request of the Michigan tribes who have federal recognition. Project 1.1 resulted in the publication of 11 notices of inventory completion. Project 1.2 was a single archaeological district, and it resulted in the publication of a notice of inventory completion and a notice of intent to repatriate. The notice of intent to repatriate described unassociated funerary objects from that site, and the notice of inventory completion described the ancestors and the associated funerary objects. Project 1.2 was separated from the bigger Project 1.1 project because the tribes wanted to take time to identify funerary objects without slowing down the rest of Project 1. The same was true for Project 1.3, which was originally part of the greater Project 1. It was separated out from Project 1 because of the massive amount of documentation associated with that excavation. The tribes wanted to take time to review those reports to determine if any associated funerary objects or unassociated funerary objects were present. That one resulted in the publication of a single notice of inventory completion. Project 3 was concerning individuals from completely unknown geographic locations. That one resulted in the publication of a notice of inventory completion after presenting the case to the Native American Graves Protection Repatriation Review Committee and getting the approval of the Secretary of the Interior. During the 2.5-year project, this client also facilitated the disposition or repatriation of individuals from other states besides Michigan. As you'll see here, Project 2 was implemented after Project 1 and Project 3. That is because the case numbers or the project numbers are arbitrary. We actually generate them automatically as we are identifying Aboriginal land tribes. So it didn't matter that Project 2 was implemented after Project 3. Using Aboriginal land research, they facilitated the disposition of an individual from LaPorte County, Indiana, in consultation with 41 Indian tribes whose Aboriginal homeland includes that state. Aboriginal land research was not as critical for the other cases, but it was definitely reviewed as part of that process of using available information to develop an inventory.
Thank you for joining us on this training on Aboriginal land under NAGPRA.
We wish you all the best in your NAGPRA compliance efforts.